I have been giving expert evidence in DNA analysis and in bloodstain pattern analysis, body fluid identification for getting close to about 20 years. There's no such thing as a gold standard. Let's put that out of our heads right now. DNA analysis is a technique. It has, I think, brought other forensic techniques along in its wake in terms of improving standards, but nothing is 100%. There's all sorts of things about DNA analysis that can be misinterpreted. So hopefully I can give you just a little bit of a background on that. When I speak to lawyers and judges, I like to, this is the requisite one thing off of the internet. Let's have some fun. Judges will tell me they have that idea all the time. Lawyers will have, why did I ever agree to try this thing? Oh yeah, they think that all the time. I have thought lots of things when I'm sitting in that expert witness box. I have never thought, boy, this is neat. And I can't tell you all the words I'd use, what's going on in my mind sometimes. But this does. I've now given evidence, I think, over 130 times. Every time I come off that witness stand, and my colleagues at CFS, the same way here, we come off that witness stand and think, I hope they got it. I wonder if they understood. There was a complicated bit in there. I hope they got that bit. But we're not there for the rest of the trial. We're not there for the closing statements. We're not there for the judge's instructions to the jury. It's almost as if, I suppose for anybody with kids here, you give them the keys to the Porsche and just hope, right? Just hope for the best. That's what we do. So in 2013, when this university made me an offer I couldn't refuse to come on to, into the faculty, I said yes. And I wanted to pursue that question. What do lawyers and judges do with our testimony afterwards? Do they get it right? Well, I might as well do this here. Next. There's not a lot of work done on this. The Australians seem to be first doing this kind of work. Cashman and Henning in 2012 wrote about this, especially with respect to DNA evidence, and they polled lawyers. And they found some interesting stuff. Essentially, the lawyers are saying, you know what, I get parts of it, but the statistics part, the mathematical analysis, the probability stuff, and gobbledygook. I think any time that the feedback that you get from your clients and the public is gobbledygook, as scientists, we have to now start looking at ourselves to say, are we doing the best job possible? It's science. It's hard stuff for people. But when the courts and lawyers don't understand it, that falls on us. That doesn't fall on the legal community. It falls primarily on us, and we have to accept that. In Australia, I guess they can poll juries. Too bad we can't do that here. Or maybe it's good. I'll leave that up to you. They did actually interview actual jurors to complete written surveys. There was one part of their findings that kind of troubled me, and excuse me for reading off the slides, but it was what I do. Some jurors, however, used the limited DNA evidence about the presence of the complainant's other sexual partners to draw adverse inferences about her credibility. So there's all sorts of things happening after the testimony here. I'm not so sure how we'd ever really approach that particular problem here in Canada. But this is our approach. No, we can't be there for all of the closing arguments and the judge's instructions, but transcripts are available. And that's what we did. We analyzed the court transcripts from criminal trials, focusing in on DNA analysis evidence, to see what they're saying about us when we're not there. So we compare and contrast the two sets of transcripts. The say versus the say about in terms of the scientific conclusions. We wanted to start with all aspects of DNA analysis, but that was just too much to bite off, so we really concentrated on the mathematics, the probability statements, and then hopefully move off a little bit more. So, 30 seconds, this is what DNA analysis is. We have DNA. It's in all our cells. The DNA that you have is a code that makes you who you are as a human being and who you are as an individual. Most of this code is the same for everybody on Earth. A small bit of it is different informationally. As scientists, we focus in on a subset of those differences, and we make a picture of those differences. That picture is your profile. Forensically, you have a profile from the scene, you have a profile from the complainant or the accused. You compare them. It's Sesame Street time. If they're different, two different people. If they're the same, two explanations. One, same person. Two, coincidence. What's the probability of that coincidence? That is what's called the random match probability. It's the probability that a randomly selected individual, unrelated to the person in question, would share that profile. That number, with the new technologies, tends to be 1 in trillions, 1 in quadrillions, 1 in more zeros than you can even imagine. It's the probability of a chance match. It is not the probability of guilt or innocence. That's an overstatement of the probability. So, you know everything you have to know about DNA analysis now. I'm not very well versed in social science methodologies. My graduate student, Don Cohen, figured out a good way of attacking this. And that was through, first of all, searching for cases. Big problem number one, transcripts are expensive. I can find the cases and I'm charged $8 a page. Well, can you imagine some of these large cases, hundreds of pages? I've blown my budget just on one case. However, if you go to the appeals court, those transcripts are already made. You can go in for $1 a page. One of my students found a 50-cent page option. I didn't ask how she did it, but I was really happy. And we found 33 cases where we had expert DNA evidence, and then opening, closing statements, sometimes opening, and judge's instructions. So that was our data set. We had to take these paper copies, put it through an optical character recognition to turn them into, I've got 6 minutes left, turn them into Word documents. We did a coding, which was essentially finding all of these bits where the scientists talked about the stats, the lawyers talked about the stats, and whether that they were right or wrong. Okay? That's what we did. So, this is an example of right and wrong. The forensic scientist said that the probability that a randomly selected individual unrelated to Ms. X would coincidentally share the profile is estimated to be 1 in 200 billion. Perfect. That's fine. The judge. The Crown also referred to the expert who testified that the DNA of the complainant was found on his boxer shorts, and that the odds that the DNA being the DNA of someone other than her was 1 in 200 billion. That's actually a flip. That's wrong. That's an overstatement of the numbers. It doesn't look like a huge problem, but it's wrong. We found, and this kind of hit my ego a little bit, that most of the time when the expert gave probabilistic evidence, the defense only mentioned it about 1/3 of the time in the closing. The Crown about half the time, and the judge a little bit more than that. So all of this time that the expert spends in trying to be right seems to kind of go for naught. The lawyers are going, ugh, it's stats, forget about it. So this is just a few bits of what we found, that in terms of jury and non-jury trials, most of the time it wasn't mentioned. Sometimes there's what's called an admission of source. It seems as if that the players are just saying, yeah, it's his DNA, or yeah, it's her DNA. This just could be an admission. But what you can see here is that the defense in a jury trial is wrong about 3 times as many times as they are being right. It seems the judges get it right more than anybody else. So good on the judges. So that's just a wee bit of our of what that looks like. I just want to show you just a few bits of the transcripts because some of it's funny, and let's have that, okay? So just tell me when to shut up. Not a problem. This is a charge to the jury, and this is a judge that gets it right. The DNA evidence is just one area of circumstantial evidence. You must not equate the probability of any random match with the probability of X's innocence by converting the DNA stats into something approaching the ultimate issue of guilt or innocence. This person obviously knows what he or she is talking about. You almost want to put that into the Watts manual and have that ready, okay? Because most of the time you'll see something like this. This is a judge again, the random match probability of an unrelated male being the donor of the sperm is 1 in 670 billion, an astrologically high number. Let's hope that that was not astrological, okay? I don't know. But that's a misstatement again. And one of our problems was that, when we're trying to code this and trying to assign, there's being wrong and there's spin, right? So this is the worst issue. This is spin. Maybe I'm wrong here, but I want to strangle someone. I've said it at the beginning of this trial, and I'll continue to say it for the rest. This is Mr. X's semen. It is not a failure to exclude at 670 billion. That's the way the scientist talks in the lab. It's not the talk of common sense, of the use to be made in a criminal trial of this evidence. It's his semen. That's the evidence of the expert. No, it's not. No, it's not. Is that spin or is that wrong? Either way, again, here's just another example. The scientist, I'll just say, is correct. The judge, the DNA analysis concluded that the sample from the bottle matched the defendant's DNA profile. The chance that the sample came from someone else was 1 in 32 billion. Again, another overstatement, not hard to find. Just to tell you where we're going next with this, the real issue, and getting back to DNA not being the 100% of anything, is asking the question of, 2 really. One is sometimes DNA is very complex, 2 minutes. In mixture profiles where you have DNA from more than one person, those interpretations can be very complex. They come with assumptions, comes with limitations. Are those assumptions and limitations that the scientist is saying coming out in the end? I don't know yet. 2, transfer and persistence. Just because you find DNA doesn't mean it's associated with a particular event. Is it possible to find DNA from somebody on an object that they haven't touched? Yes or no? Yes. I have seen my DNA on an item at Center of Forensic Sciences where I wasn't there. Why is it? I had a student that was working on a project there. She visited my lab, got the DNA from my desk onto her lab book, from the lab book into her book bag. She took the book bag over to CFS. She started doing the analysis. She was handling one of those 3D guns, and my DNA ended up there. Think about that, okay? And that's where, as I say, we'd like to take this. I've just started a little bit of this work now, and without going through some of this, what's happening is this, is that it's a Wild West. It's a Wild West. Lawyers are going into inferences without the experts even being asked the particular questions. So I'm really looking forward to this. I don't know how we're going to code this yet, but we're going to look at the experience we had with the random match probabilities and try to assign it here.